Speaking of those topics, our agenda today, I'm going to give you a little bit of an update on the Supreme Court ruling and the effect. We're mostly out of the woods, but there's still some things lurking in the background. We'll break that down for you here. But essentially, it's full steam ahead with implementation. Today's main topic is doing a comparing and contrasting of the Bank Secrecy Act's beneficial owners compared to the 1071 principal owners. Now, why are we doing that today? Well, they sound really close together, right? And the two rules are definitely something that occurs within the commercial lender space. And so what they know about beneficial owners is a double-edged sword, because it's going to help them with some things when it comes to 1071, but I think it's also going to be a bit dangerous because things aren't always as they appear. They're not exactly the same. In fact, far from it. So what we're going to do today is tackle the beneficial owner requirements. We're going to do a quick redo on that, rehash it, make sure that you're aware of what that rule looks like. And then we're going to bring the principal owners to the table. And we're going to go through that quickly. Then we're going to go through side by side and compare them. Here's what this requires, here's what that requires, and what makes it different. Okay, and then I've got a little treat for you at the end, a little surprise that we'll talk about when we get there. As always, we'll bring to you the commercial lending aspect, something for your commercial lending, your business line. We'll give you some things to chew on with your management and board of directors as well, and then obviously explore. So that's what's on the docket for today. Also, want to remind you that as members, month in and month out, as you stay current with your membership, any 1071 related webinar that we do in that month, you get access to at no extra cost. So we've got a real big value coming for you here in August. Okay, when you're a member in August, you get access to the three-part 1071 deep dive compliance webinar series. 6 hours of 1071. Yes, we did this a year ago. If you were members then, we're going to respin it again here in August, and we have learned a ton. A lot of it as a result of this group and the ability to deep dive. We're going to bring that updated, evolved version to you on August 1st and then the 8th and the 15th subsequently. So as members, you're going to get access to that as long as your membership is up to speed. And we've got some other things we're working on too. I made a note here. One of the things that I'm just getting started on is 1071 for the front line. Why am I just getting started on that now? Well, now we have the end of the road. We know what it looks like. We know what your dates are. We'll get to those in just a bit. So ahead of that, your front lines are going to have to go to work soon, right? We're going to have the practice year. We want to be prepared for that. And then the go time, right? Your absolute go date. So training just for the front line. And so that is going to be a less time frame than the part series that is, or the 3-part series that is 6 hours. So look for that. And again, you'll get that as members of the group at no extra cost when we get that on the schedule. Again, just starting to build those materials. So mark those dates. All right, let's hit our first topic here. Page number 4 in the materials, Supreme Court ruling effect on 1071 implementation. So the quick recap. Just a reminder that when the CFPB went before the Supreme Court, it wasn't about 1071. Okay, it was about the funding. Okay, the way the CFPB was funded. That's what was taken to the Supreme Court. Now, it had an effect potentially on everything the CFPB had done up to that date, whether it was enforcement actions, rulemaking. Okay, anything they've done could be called into question if they had lost at the Supreme Court level. Well, they didn't. Okay, they prevailed by way of a 7-2 vote. So what's that mean? Means we're back moving forward. In fact, I read something just this morning. They're full steam ahead. They had a lot of things they were just sitting on, like maybe you heard of this before. They were looking at ramping up enforcement. I mean, no surprise, right? But looking to add 75 new enforcement employees to their team. Well, they had to hold off on that because their funding was called into question. Well, now they're funded again, and they're full steam ahead with pulling new employees in to help with enforcement. All the rules, the rulemaking agenda, full steam ahead is what I read this morning with what the happenings are at the CFPB. So with 1071, that means implementation's back on the table. It really never went away, at least in this group, but full steam ahead towards your mandatory compliance date. And, could there be some things that occur, in the background? Yeah, the Supreme Court only ruled on the CFPB in relationship to their funding. There were other things in that Texas court case that are going to be sent back to Texas to decide. I've heard that there are still people holding out hope that the Texas court might come to a conclusion that the CFPB has to rewrite the regulation that's used to carry out 1071. Yeah, maybe. I don't know. I'm not going to hold my breath for that. The people I've talked to, they don't seem to think that's going to happen. And if a rewrite did happen, they're not throwing the whole thing away, not starting from ground zero. Okay, it might be slight tweaks. But at this point, with the dates that are now out there, we need to be full steam ahead with implementation. And that's what we're here to do today and next month and the oncoming months with this group. And hopefully you're doing that with your teams as well.